Welcome to the fifth of our regular updates, highlighting what's happening and changing in relation to employment law and practice. In this episode, we cover the latest news on the Employment Rights Bill now that the MPs have returned from their summer break, and we take the opportunity to focus on recent decisions which highlight how wide some existing rights already are in relation to data breaches, employee liability for workers' discriminatory acts, and whistleblowing. So, first to the Employment Rights Bill, which returned to the House of Commons for a debate of the House of Lords amendments now that the MPs are firmly ensconced once again after the summer recess. The government has also remained strong in its support for the bill, despite the unexpected loss of one of its champions, Angela Rayner, as a minister. Consequently, as expected, it rejected all the amendments made by the Lords, other than those which received government support, see our earlier video updates, and some technical changes that the Lords had made. See the tiny ULR, which sets out the changes and reasons for rejection, which now goes back to the Lords for consideration. These changes include additional amendments and the restoration of words removed by the Lords. In anticipation that there will not be too much ping-pong between the Commons and the Lords as they try to resolve these disagreements about the final text, we currently still expect the bill to receive royal assent by the end of this month, beginning of October. You may be entertained to learn that ping-pong is the official phrase for this toing and froing between the houses. In any event, we hope to have news in our next video update for you. And on to data breaches. The Court of Appeal has recently considered the compensation recoverable for such breaches. Previously, the Supreme Court had held that the loss of control over data subject's data is not, in itself, enough for award of damages, and the data subject must be able to show that they suffered actual financial loss or distress. This was decided under the Data Protection Act 1998, which has since been repealed. This left the Court of Appeal free to consider if the introduction of the UK GDPR and the Data Protection Act 2018 had changed this position. And it did. No proof of material damage is needed. Instead, a test of reasonableness should be applied. That is there a reasonable basis for the data subject fearing that their personal data had been or would be accessed by one or more parties, and that this would result in identity theft or one or other consequences which the data subject feared might follow. This decision removes a significant hurdle to claimants bringing claims arising from data breaches, so we may see an increase in these claims. Much of this risk can be mitigated, though, by implementing robust data protection and data security measures to prevent inadvertent data breaches of this nature. Employment Essentials has further guidance and modelled documents to help. The Employment Appeals Tribunal has also given guidance on what amounts to occurring in the course of employment in relation to employer liability for discriminatory acts committed by its workers. This has been widely construed, although again it will depend on the specific facts. One relevant factor may be whether the act was done in or out of employment, and if the act takes place out of employment, whether or not there is a sufficient connection with work so as to mean the act nevertheless took place within the course of employment. In this case, sexual harassment had occurred out of work during an unscheduled car lift to a worker's home, after the worker had erroneously turned up at the offices for a job for which she was not required. Among other things, the Employment Appeal Tribunal held that the tribunal, in deciding the case, had failed to consider the harasser's previous conduct to the victim, the reason why the victim was in the car, and that the harasser had previously given the victim a lift to a job. It was also potentially relevant that the harasser had taken advantage of the fact that the victim thought, albeit mistakenly, that she was due to work and that he was offering her a lift as part of his duties. The case was therefore sent back to the tribunal to be reconsidered on this basis. And finally, on to whistleblowing protection. The Employment Appeal Tribunal has looked into whether disclosures made to a third-party investigator was within the employer's internal disclosure procedure, so that disclosures would be protected. Once again, while this depends on the facts, in principle the answer is yes. An employer cannot avoid disclosures from being protected merely by pointing to the absence of an employment relationship between it and the person receiving the disclosure. Internal disclosures, that is, disclosures to the employer, can include further disclosures to an external third party who has been charged by the employer to investigate the employer's compliance after the initial disclosures have been made, in this case in relation to procurement and contract rules. And just to end on a recent example of whistleblowing protection in practice for you as we're hurtling to the colder months. In this case, an employment tribunal has held that a shop worker had been automatically unfairly dismissed after they were fired for blowing the whistle about their cold workplace. Here, a cafe door was left open to increase footfall, dropping the temperature to under HSE guidance requirements. The employer's insistence that the dismissal had been for different reasons was not believed by the tribunal. And that's it for this update. Do have a look at our tiny ULRs for our free podcasts and blogs. And if you've not already done so and are not a subscriber, please do request a demo for Employment Essentials. It's full of up-to-date guidance, information, practical solutions, and ready-to-use workplace documents. Goodbye for now.